one of the last acts that President Biden did in his time in office was to formally proclaim, I can't hardly talk, proclaim the Equal Rights Amendment is now law. And actually, the ERA was ratified by 38 states back in 2020. So it's been valid for about 3 years. And probably more lies have been told about the ERA than perhaps anything out there that the political right and people who really should know better have been promulgating. The one thing that people haven't figured out, and Lawrence Tribe here writes about the ERA, and he knows what the hell he's talking about because he was in the trenches back in the 70s getting this ratified, passed in Congress, and ratified in the states. He's a key figure. So he knows what he's talking about. He's one of the leading legal scholars in the United States, if not the preeminent legal scholar and constitutional scholar. So anything that you read by attorneys who write columns for publications like Slate or Salon or the AP or whatever, they don't know what the hell they're talking about if they're saying the ERA is not valid. That was a lie that was put forth by the political right in the 80s, and it was completely underreported why Congress didn't extend the ERA further. See, there was an advisory resolution that had passed with ERA, but it's not part of the Equal Rights Amendment back in 1972 that said 7 years for ratification. And then in 1979, the 7 years had come up, and Congress approved an extension of 3 years. Well, then all of a sudden in 1982, supposedly the ERA had expired, and of course, if anybody wanted equal rights for women, you had to start all over again. None of this was valid. Well, guess what? There is a reason why Congress did not extend the ERA further in 1982. And Lawrence Tribe, in this article, which I will post in the description, says the Supreme Court, in a case that one of us, Tribe, presented to that court over 4 decades ago, National Organization for Women versus Idaho, similarly treated the time limit in the resolution as non-binding. That is why Congress didn't put any more extensions in, because any kind of time limit was not legally binding. So what was the point? But do you think the media actually published that? No. They thought Phyllis Schlafly, backed by the insurance industry and a right-wing hack to boot, and her Eagle Forum army of housewives, defeated the amendment. They were successful. No, they weren't successful. But that case was not reported widely in the media at all. But that's why Congress didn't move to extend the deadline, because the deadline didn't mean anything. So anyway, and they go on to say, Lawrence Tribe, and although 5 states, Idaho, Kentucky, Nebraska, South Dakota, and Tennessee, attempted to rescind their state legislatures' earlier ratifications of the ERA between 1972 and 1982, nothing in the Constitution provides for any such turnabout, nor tolerates the chaotic and unpredictable legal situation that would be created by permitting states to reverse course as the process proceeds. Ratification is rightly understood as a one-way ratchet. The only way a constitutional amendment can be repealed is through another constitutional amendment. And the case in point is prohibition. It was put into the Constitution by the regular process, and when they found that that was a failure, when politicians and public opinion said this is a failure, they put another constitutional amendment in to repeal it. That's the only way a constitutional amendment could be repealed. So we've had piles upon piles upon piles of lies about this law. And we have dishonesty still continuing, thinking that this has anything to do with gender identity or any of that other stuff. Because that was a crap that Phyllis Schlafly pulled years ago, and it was not valid. And so what we have is basically it's in all intents and purposes, it's the law of the land. Now the archivist is an ignoramus and probably a Republican hack. She's a national archivist. It is not, but anyway, she claimed that she wasn't going to adhere to her statutory and purely ministerial duty to publish the ERA. The only reason Congress gave the archivist, this is Tribe again, such a duty nearly a century ago was to ensure that the nation got word that an amendment was in force, enabling officials at all levels of government to conform to their actions to it. And that's not necessary today. So actually, the ABA and experts like Lawrence Tribe say, yes, the ERA is the law of the land. Deal with it. Okay? It's not going to be reversed. So anyway, that is all I have to say about it.